one of the many reasons why it makes sense for a mediator to become involved in the process early in guided choice dispute resolution is it provides an opportunity for the mediator, who's also sometimes known as a neutral, to work with the parties to establish a process. And that's a key word, process, which can avoid some of the typical pitfalls of mediation, right? It's a way for the parties working with the neutral to figure out a way to discuss the possibility of a mutually agreeable settlement without unnecessarily antagonizing each other, which is something that happens in a lot of mediations and results in the parties, unfortunately, going to war, or at least getting further apart from settlement and launching down an inefficient, time-consuming, and expensive process, which almost always results in the parties settling their case on the eve of trial, probably on terms that they wish they would have arrived at years earlier. Now, look, I think it's debatable. No matter what you think about mediation, and believe me, mediation is no panacea. I've had a lot of really bad ones. But it is undebatable that most commercial design and construction disputes are not litigated or arbitrated to a binding outcome, right? Because preparing for trial or arbitration can be very expensive, particularly in complex cases. And frankly, even in cases that aren't that complicated, now in the age of electronically stored information, like emails and text messages that have to be produced, almost any piece of litigation or arbitration can get quite expensive. And now those costs will grow, and this is important, in proportion to how long a dispute is around before the parties are able to reach a settlement. So regardless of what you think about mediation, and I'm certainly not suggesting that it's wise to surrender or to give up your client's position or your position in the sake of baby splitting or surrendering or anything like that, certainly not out of any blind love of mediation. But I think that we can all agree that earlier is better. If it's possible to achieve early cost-efficient dispute resolution on terms which make sense for your side, it's certainly better for it to come earlier than later. And if you're thinking about whether and when to hire a mediator to resolve a commercial design or construction dispute, it's also clear that the parties, for some reason, are stuck, right? And the question of how to settle, how to get to a resolution, when the other parties show no interest in backing off of a position that's already been rejected by their opponents, is difficult. It's one of the things where having a neutral involved early, it can really be constructive. And I don't know that I agree with many litigation attorneys' position that more litigation discovery, more depositions, more exchange of documents is what's necessary. I don't know that I agree that it necessarily always helps the parties understand the strength and weaknesses of their arguments. Certainly there is some of that, but oftentimes it tends to lay bare the fact that both parties have arguments to make, and each one tends to look at the world using selective attention to facts, whatever's most beneficial for them. And clarifying those strengths and weaknesses, clarifying what this side believes is their best points and clarifying what this side believes is their best points, in many cases only escalates an impasse as each side props up the strengths of its case in the hope that doing so will overcome its weaknesses. And so what you wind up with, if you do not get a neutral involved early and have a thoughtful process along the lines of what's contemplated by guided choice dispute resolution, is expensive and time-consuming discovery conducted on an adversarial basis, which is focused primarily on bolstering the strengths of the parties' positions, which again, I don't think is always constructive. It tends to lead to overconfidence bias. Advocates fall prey to having one eye closed as they focus on the strengths of their case, and then they're met with opponents who are doing the same. And this overconfidence in the merits of their client's position leads to an almost unintentional blindness regarding the opposing party's position, why it might be reasonable. So I don't know if I agree that this expensive and time-consuming discovery, this evidence gathering, this aggressive, antagonistic discovery, which is conducted by lawyers who drive antagonistic behaviors, I don't know that it's constructive. And I think it's what happens a lot of times when you don't have a thoughtful dispute resolution process along the lines of what is contemplated by guided choice. The conflict escalates, the parties go to war, and the window of opportunity for a mediation has passed. And this is one of the many reasons why I believe early neutral involvement, in other words, early involvement of a mediator who understands the guided choice dispute resolution process is essential. It's essential to get them involved and to get a constructive process in place before the parties' window of opportunity for constructive dialogue around settlement passes and they're forced into a destructive litigation or arbitration process, which in my view is not consistent with achieving their interests.